So welcome to this year's Arthur Allen Leff Fellowship Lecture. Arthur Allen Leff was a professor at the Yale Law School until 1981, when he died from cancer at the inconsolable age of 46. He taught contracts, evidence, and ethics to scores of students, including myself, and was, without a doubt, among the most brilliant and formidable intellects of his time. Few individuals associated with the Yale Law School better exemplify the values of this institution or are more responsible for its reputation. As a scholar of contracts, Arthur Leff transformed our understanding of unconscionability, and he argued compellingly for the law to approach consumer contracts as things rather than as processes of consensual bargaining. As a teacher, he was, and I can report this from personal experience, one of this school's most popular professors. He was always peppering his lectures with references to Bach or to Shakespeare and words of his own concoction, like fraudlet. As a friend, I remember most vividly his wit, which was dry and sharp and pungent, but always sweet, always human at the core. He was once at a seminar conducted by Henry Manny on law and economics in some rural area, and when Alan Schwartz asked him how it was, he replied in a flash without waiting for a second. He says, "It was Pareto in the Pines." Some sensibility. Art's work was beyond genre and discipline. It drew on innumerable intellectual sources. It was audacious, it was provocative, and it was courageous. It dared to stare the blank universe directly in the face. As he cautioned us in a marvelous piece called Unspeakable Ethics, Unnatural Law, he said, I'm quoting him, he said, "It looks as if we are all we have. And given what we know about ourselves and each other, this is an extraordinarily unappetizing prospect." With this annual lecture, we celebrate the career and life that was, and we mourn not just the man, but the contributions to the law that were still to come and caught tragically short. We seek to recapture Art's dazzling passion for thinking and to invite to Yale Law School scholars whose work in other disciplines illuminates the relationship of the meanings of law and legal institutions. And our speaker today is certainly up to those challenges. Jenny Mansbridge is one of the towering figures of contemporary democratic theory. She is currently the Adams Professor of Political Leadership and Democratic Values at Harvard's Kennedy School of Government, which she has taught now for almost 2 decades. Before that, she taught at the University of Chicago, at the University of California at Santa Barbara, and at Northwestern. And at every stage in her career, Jenny has addressed topics that matter to those who are engaged in the democratic enterprise, including the virtues of descriptive representation, the necessity of both compromise and creative negotiation, and the importance of social movements. In 1980, Jenny published her first path-breaking book, Beyond Adversary Democracy, which explored the differences between what she called adversary and unitary democracy. Adversary democracy assumes that citizens' interests are in constant conflict and that they can only be reconciled through elections and majority rule. Unitary democracy, by contrast, envisions a deliberative process capable of identifying common interests and reaching consensus. Mansbridge convincingly argued that modern politics depends upon both. By offering in-depth studies of how 2 real political communities, a New England town and a small democratic workplace, actually functioned, Jenny teased out the ways in which the adversarial and unitary visions of democracy can fail or flourish, extrapolating from her empirical work to draw conclusions about national politics and democratic theory. Bennett Berger, an editor from the Journal of Contemporary Sociology, wrote that Jenny's book attempted, quote, "nothing less ambitious than the theory of democracy and its problems of equality, solidarity, and consensus, and he affirmed that it was, quote, not simply a work of political theory, end quote. In the 1980s, I'm going to say, very few political theorists took their work outside of their offices and their libraries. Jenny was, and she still is, different from that. She has no fear at all of engaging and theorizing the actual lived experiences and social frameworks that give politics meaning. She followed this first book with an award-winning study entitled Why We Lost the ERA, which paid very close attention to the dynamics that led to the defeat of the Equal Rights Amendment. This was her first of many incisive commentaries on identity, social movements, and deliberative politics. Her work in this vein on representation includes the stirring article, this is the name of the article, Should Blacks Represent Blacks and Women Represent Women? A Contingent Yes, that was published in the Journal of Politics in 1999, and Clarifying Political Representation, published in the APSR in 2011. Most recently, she has edited a volume on deliberative democracy called Deliberative Systems, which seeks to explain how the deliberative ideal of democratic engagement can operate not just in small communities, but at a national or even a global level. The volume has been praised for its unique ability to bridge theory and practice, examining how we actually confront the problems of implementation in a real world of competing norms, competing institutions, and competing powerful interests. Jenny is a prolific political theorist who, in my view, extends the tradition of the great empirical political work of figures like Montesquieu, Tocqueville, and her Kennedy School colleague, Robert Putnam. Her work, to me, has the remarkable and unique quality of combining the utmost theoretical rigor with an almost infallible sense of the topical, the practical, and the helpful. I want to give you one additional example. As president of the American Political Science Association from 2012 to 2013, Mansbridge led an effort to study the causes and the consequences of political polarization. She was motivated by the pressing and shared needs of our country. To use her words, our democracy is drifting, which I interpret to mean that our ability to govern ourselves is stalling into freefall. Jenny understood that the status quo is toxic, eroding our civic institutions, markets, and everything else that we value day after day after day. And she said modestly that, quote, in this moment of crisis, the APSA thought it would be helpful to bring forward what political science knew about negotiation and to put it before the American public and the members of Congress to make clear how important negotiation is for democracy. So her determination to affect our nation's dialogue and institutional practices are clear from the very first pages of this really wonderful report. The table of contents, beginning with a chapter on the human brain and concluding with lessons from international negotiations, reads like a toolkit for addressing our contemporary breakdown in democratic discourse. And the report's conclusion exhorts Congress to action, quote, only through deliberative negotiation can the government use its collective intelligence constructively for the good of citizens of both parties and for the country. And in my view, this report was an act of statesmanship as fine as any in the history of the APSA. Jenny's work is invariably illuminating. It exemplifies the mastery of the most important topics of democratic theory, and it shines with common sense. If I am working on a problem, and I'm not saying this hypothetically, because in the last several years I have worked on such problems, I always look first to see what Jenny has published in an area, because I know that if I have read her, I shall have read what is most important in the field. Today, Jenny will turn her attention to the need for legitimate coercion in a democracy. We need coercion as increasing integration nationally and internationally require greater public goods. How legitimately to exercise that coercion poses a looming crisis in democratic legitimacy. And facing facts, as she always does, Jenny has entitled her lecture, Legitimate Coercion, Not Just Matter of Consent. Let me say in closing how admirable and remarkable it is that with each passing decade, Jenny has advanced our understanding and our practice of democratic government. She has taught us what it means to be more deliberative, more committed to equality, and more committed to self-government and to each other. Arthur Leff would have loved Jenny's ambition. He would have admired her practical good sense. He would have applauded her values, even if all the while he might have remained skeptical about her faith in our ability to improve our sunken condition. But if indeed we are all that we have, as Arthur long ago affirmed, then Jenny Mansbridge gives us hope that indeed we have enough. Please join me in welcoming.
Bob, that was the best introduction I have ever had in my life. That was wonderful. You perhaps praised my work too much, but you understood it deeply. Thanks very much for inviting me today. I appreciate it, particularly because I feel a certain sense of urgency about what I'm going to say today. And I can't think of a better forum dedicated to Arthur Leff to say it in. Thank you very, very much. So you noticed that Bob called me Jenny. That's because Jenny's my nickname, and so I welcome you all to call me Jenny, because I don't like distinctions between people who are in and people who are out. So now you're all Jenny to you all. Basically, the lesson I have for today is that our need for collective coercion is outstripping our capacity to legitimate that coercion. We're in desperate straits these days, and the need for coercion, that's our problem. So I'm going to begin by talking a little bit about coercion, the handcuffs, and then I'm going to be hoping to get you to appreciate it, and then I'm going to talking about how to make it legitimate, if we can, to the degree to which we can make it legitimate. And that means all the way down. So I'm going to talk not only about legitimacy at the legislative level, but legitimacy at the level of the point of implementation. And along the way, I'll make some counterintuitive suggestions, a couple of which Bob has somewhat signaled. But before I do, I want to read something from Proudhon. Not really a nice man, an anti-Semite, but he had a fantastic way with words. And I had these words on a wall of my study as I was a graduate student. To be governed is to be watched, inspected, spied upon, directed, law-driven, numbered, regulated, enrolled, indoctrinated, preached at, controlled, checked, estimated, valued, censured, commanded by creatures who have neither the right nor the wisdom, nor the virtue to do so. To be governed is to be at every operation, at every transaction, noted, registered, counted, taxed, stamped, measured, numbered, assessed, licensed, authorized, admonished, forbidden, reformed, corrected, punished. It is under pretext of public utility and in the name of the general interest. To be placed under contribution, drilled, fleeced, exploited, monopolized, extorted from, squeezed, hoped, robbed, and then at the slightest resistance, the first word of complaint, to be repressed, fined, vilified, harassed, hunted down, abused, clubbed, disarmed, bound, choked, imprisoned, judged, condemned, shot, deported, sacrificed, sold, betrayed, and to crown it all, mocked, ridiculed, derided, outraged, dishonored. That is government. That is its justice. That is its morality. And I thought he had a bit of a point. And it's much the same point as back in the old free speech days, taking from the IBM card, please don't bend, fold, spindle, or mutilate me. And prisoner number 9, I will not be pushed, filed, stamped, indexed, briefed, debriefed, numbered. My life is my own. And I appreciate that. I also want to help you appreciate coercion. And by coercion, I'm going to mean the threat of sanction or the use of force. And I'm just going to go back to the logic of the old free rider problem, which was discovered in the middle of the last half century, which comes from the free rider problem, derives from the nature of what I'm going to call a free access good. And it drives only from that. So when you see a free access good, you're going to have a free rider problem. If you don't see a free access good, no free rider problem. What's a free access good is just one that once somebody brings it into being, anybody can use it freely. The economists often use the word public good, but public good slips in the second feature of being non-rival, and I don't want to have two features. I want to focus only on the one feature. So public good confuses the issue by bringing in another feature. The feature that I'm going to point to, free access good, has been traditionally called non-excludable good. Duncan Snidel, in a paper quite a while ago, full of equations, showed that that was incorrect terminology because, after all, if you use up a free access good, it's no longer non-excludable. You're excluding the people who come at the end. Got published. I checked with Duncan to see if free access, he thought free access managed to avoid that problem. He agreed that it did. So now I'm suggesting that we just substitute the free access term. So common defense is a very traditional version of this. You know, some people provide the common defense. You don't have to. Even if you haven't given up, you're taken up arms for your country, even if you haven't paid taxes to defend the country, you benefit from defense. You benefit from law and order, even if you are breaking the law yourself. You benefit from non-toll roads, whether or not you've contributed to paying for them. So, of course, if you can use it without paying, you're going to usually try to avoid paying. This isn't true of everything. Some things are fun to contribute to, like the Wikipedia. So the Wikipedia is a free access good, but it's not one that we need coercion to make people contribute to, because it's fun to contribute to the Wikipedia. But it's not so much fun to go out and build a road, and that's why we, in order to get roads built, if we just waited around for people to sort of cough up money voluntarily for roads, we wouldn't get as many roads as we need. So we need the standard response to the free rider problem is to produce coercion. Not in a small, formal coercion, not in a small village where if you don't contribute to the irrigation system or if you don't help till the common field, I can scowl at you, or I can not let my children marry your children, or there's all sorts of things I can do. But in where you don't carry, in a society where you don't carry your reputation with you, where it's anonymous, we need some more formal coercion. So that's only one reason for government. I'm not stacking this is not an economic theory of the state. There are many other reasons for government, but I do want to focus on this one. And I want to just quickly point out, we can make lots of things into free access goods. It's not as if there are some sort of free access goods just out there. We're able to do that. Now, one reason for my urgency in this is that obviously a break on climate catastrophe is a major free access good. We all benefit from it, whether we contribute to it or not. And the fact that it's a free access good ought to immediately make us alert us to the fact that we're going to need coercion to solve it. Our interdependence these days in our world produces a huge demand and sometimes need for a whole ton of free access goods. And I think of blueberries on our table in wintertime. When I was a kid, the time you ate blueberries was in blueberry season. But now I can just go at Stop and Shop and get blueberries. How? Okay, well, Chile has some of the strongest food safety standards in the world. That's a free access good that we get to benefit from those food safety standards. Chile produces information to the state produces information to the blueberry farmers as to what the climate is going to be, the crops are going, what the prices are, what it looks as if the prices might be. It produces information on how to produce good blueberries. It helps that whole blueberry enterprise. Of course, then the blueberries get onto roads, they go to harbors, they get onto boats. The boats have their rules against the boats putting their emissions into the sea. et cetera, et cetera, et cetera. You get here, Harper's Road Law and Order. The number of free access goods that it takes to produce those little bloopers on my table is immense. And the more interdependence we have, the more we need this. And obviously things like controlling Ebola require a great deal of coercion too. I don't doubt if there's a single case of Ebola in this room, and that's a wonderful free access good. We benefit from it whether or not we've contributed to paying for it. But someone has had to pay for it. And where does the money come from? It has to come from our taxes and so forth. Okay, so let's assume I've persuaded you, I hope, that you ought to be welcoming coercion, that you're saying yes to coercion as something that facilitates the life that you want. How we need to design that coercion, of course, to be minimal. Each of these things would be a lecture in itself. Well designed, i.e., well, a question period. Appropriately constrained, and that by appropriately constrained, I mean that as we welcome coercion into our lives, at the same time we're going to have to build up appropriate paths for constraining it. That will be new paths, there'll be different paths, they'll have to be rethought, and new things will have to be introduced as a way of constraining that coercion appropriately, not stopping it, but bounding it. What I want today to talk about is how we make coercion legitimate, not those other things which could be other lectures in themselves. When people, why is it so important to be for it to be legitimate? Well, empirically, whenever you think a law is legitimate, you're more likely just to obey it without being forced to. If you think that it's legitimate, you're more likely to obey its spirit rather than its letter. You're more likely to further it in other ways voluntarily, and also to punish people voluntarily. If and there's Tom Tyler nodding his head sagely, and the reason he nods his head sagely is that I've known Tom from the beginning, followed his work very closely, and this derives from his work, which I recommend to you all to read. So, by legitimate, we mean that it means right to, legitimacy means right to rule, and legitimate coercion would be coercion exercised by right, but that word right is open now, and that's what I want to try to fill in now. But before I do, I want to make a distinction that later I'm not going to undermine, but I'm going to complicate. It's an important distinction between what normative theorists call empirical legitimacy, namely just people's belief that something is legitimate. It could be a completely manipulated belief. It's their belief that's doing all that work in helping them, obey the law and punish people voluntarily obey this. It's just the belief. But in a good world, the belief would be backed up by reasons, good reasons. That the belief would be based on something appropriate, which is what normative theory is all about, trying to figure out when is this act of coercion rightfully exercised. So I'm going to talk about two levels. The first level is the legislative level, the level of actually the law. Is a law legitimate? And I would say that 90 or 95% of the work in my field, normative theory, democratic theory, is about the obligation to obey a legitimate law. It's called political obligation. There are many books about it. And if the law is legitimate, then you're supposed to obey it. Of course, some people don't obey, and then those people have to be coerced. Then there's the question of what makes that coercion legitimate. And this top feature, this top area of inquiry, the one that almost everybody looks at, the one that 95% of political theory is about, is an individual problem. Do I have a personal obligation to obey the law? Now this is also an individual problem. Should I go along with the cop at my door or not? But it is also more of a social problem. It's also a question of, do we think that, do all the bystanders who are watching the cop arrest the person, do we think that that coercion is legitimate? Now, so I'm not drawing an absolute distinction between these two, but this one is at the legislative level, this one is at the point of implementation, and I want to talk about both of these today. So I want first to talk about legitimacy, the old-fashioned, I mean the one that most of the literature is about, and make the argument that, as the title of the talk said, that it's not just a matter of consent. So, does legitimacy come from consent? I will argue that it does come in part from consent, and that's because consent is so primordial. Consent will cut across a lot of things, not everything, but a lot of things. So particularly if you're in some kind of chaotic situation, I can create obligation instantly by saying, I promise. That performative changes instantly the relationship between you and me. I now am obliged to do what I promised, and you now have a claim by right on me. Out of nowhere, I've created order based on that promise. And so, in the Middle Ages, the feudal system was based on a whole set of contracts, because there wasn't any other kind of government going on much. When Hobbes wrote the Leviathan, the civil wars had just ended, and were probably going to go on. Disbanded armies were roaming the highways. A lot of people that Hobbes called masterless men. That was the person he was aiming at, the masterless man. The population of London had tripled, and 2/3 of it was outside the walls of London. That means not subject to the laws of London. These were people without law, without master. And what do you need in that kind of complete chaos? You need a promise, a contract. Similarly in the frontier, and these days in international relations. The treaties that came out of the UN Declaration of Human Rights have cut across international chaos and created for all of us obligations and rights, for almost all of us, because of course not every country follows through, including the US, on these ideas. But the promise that you will follow the treaties on human rights cuts across chaos to create obligations and rights. So I would say yes, legitimate law does depend in part on the citizens. See, there goes the citizens promising to obey the law. The lawgiver is promising to do what the citizens say, and popular sovereignty coming from a kind of set of mutual promises. But I would say that it doesn't stop there, that legitimacy is not just a matter of consent. It's also a matter of the quality of the consent, the quality of the processes, the quality of the adding up processes in the elections, which you're supposed to have to make it legitimate. It's supposed to be one person, one vote. We know actually that we're quite far from that in most countries, but particularly in the United States recently. That fairness, the deliberation, not just now, but in the past, the fairness of the procedure, respect for persons, you could call that equal consideration and respect, concern and respect, voice of the affected, telling the truth isn't usually put in there, but I think very much of Eastern Europe and the Soviet Union. One of the reasons that those states lacked legitimacy was because they didn't tell the truth. The laws were based on lies. The kind of what you got from the government and what went into the government's decisions were lies, and that was deeply legitimating. So what is this? This is a plural theory, and it has some affinities with what Chuck Bites called complex proceduralism, but basically it's highly philosophically unsatisfactory. There's nothing more philosophically depressing than a list. You know, now I could try to derive all this from, you know, what you would agree to in the original position, or I might try to derive it all from Republican freedom, or I might try to triangulate and derive it from a bunch of things, original, you know, the original position and Republican freedom and utilitarianism, and I bet I could probably, you know, but actually, I think that human beings are list-like. I think we have many things that go into our values, and that, wonderful as it is to try to derive it all from one thing, that the way we work normatively, the way our ideals work, the way our brains work, the way our cognitions work, is a little list-like. So I'm going to stick with a list until the question period, when one of you comes up with a thing that will order all this perfectly under some other procedure. I'm going to skip some of this. Now, think about consent itself. What I'm going to argue is that these things are not only in addition to consent, but then if you think about consent in a different way, they're prior to consent. Because back in Hobbes's day, he posed a choice between either you choose government or you choose a war of all against all. And if you don't want a war of all against all, then you've got government. You've given your promise to government. These days, you're more likely to have something like a choice between an authoritarian regime and a democratic regime. Not complete catastrophe and awfulness, but bad and a little bit better. When you choose one of those regimes over the other, why do you choose it? I would argue that you choose it because of these reasons. So that consent actually comes second. Consent is what you do because of these things. So it's not just consent plus these things. I think these things can be argued to be prior to consent. In any case, I would love to go on about that, but I'm not going to, because I want to get to the other part of the thing, namely the point of implementation. But before I go on, and while we're still at the point of the law itself, the legislative act, you realize that this is always a spectrum. No, you never get to full legitimacy. All of these ideals are regulative ideals. You can, it's close to impossible to have a perfectly fair procedure. We never reach equal power in aggregation. We never reach no power in deliberation. These are things that we're moving toward, but we never get anywhere really super close to them. So no law is fully legitimate, and no act of coercion is fully legitimate. It's a matter of more or less, a spectrum. Not, even though in almost all the literature, the words that are used are legitimate and illegitimate as a spectrum, as a dichotomy. I would argue no, it's a spectrum. So I want to talk now a little bit about this chain of legitimacy, from the top to the bottom, and begin at the top very quickly. A couple of quick facts that Bob alluded to that come from a couple years ago when I was working on this issue at the APSA. We all know that the U.S. is more polarized today than it's been since the time of the robber barons, more than 100 years ago. And my argument right now is going to be that that's not going to go away because after President Johnson signed the Civil Rights Act in 1964, the Southern Democrats slowly left the Democratic Party. The two parties became more ideologically coherent, and there's no reason to suggest that that's going to change. Since 1980, we've had parties that have been very competitive in Congress. Before that, you had kind of Democratic hegemony, but since 1980, it makes sense for each party to think they might win the next election. If you might win the next election, it is in your interest to keep the party in power from doing anything, so that they can't run on it in the next election. So since 1980, we've been in a structural position in which each party has the incentive to stop the other. Of course, this helps the Republicans more than the Democrats, because the Democrats are more the party of change, but still, it's incentive for both parties. And then there's inequality. Inequality seems to track polarization incredibly well. We have no idea what the mechanisms are. but it's hard to look at a couple of graphs like that and not think that there might be some causal relationship somehow. But I'm not going to take, but if there is any, I don't know whether there is, but if there is any causal relationship between polarization and inequality, inequality is not likely to go away either. So, and the reforms that we might put in, our report a couple of years ago showed very little hope of getting much out of redistricting with primary reform, and as you all know, campaign finance reform has not got much chance, at least in the near future either. So you have this situation of polarization on top of a deeper structure, which you all know is filled with veto points intentionally. I think Bob Gooden made this logic wasn't precisely worked out in the Federalist, but it seems pretty clear that the idea here is that, the more veto points you have, the more likely it is that only the common good will manage to make its way through. And that's fine if you don't have to do very much, which they didn't think they had to do back then. So it works very well. But the problem is, what do we do with the new normal? And we could just say, well, we're going to have more executive power. We're going to have more court-making power. Or we could try, there's normative problems with both of those, we could try to see what we can do with Congress. And that's what I'm going to very briefly focus on, that if we're going to get anything out of negotiating in Congress, we're going to need long incumbencies, privacy, and the side payments. But the thing about those three things is that they're exactly the opposite to what most normative democratic theorists have been sort of prating was important for democracy. So long incumbencies, no, democracy should be about contest and turnover, and in fact, if you look at any reform sites on the web, they'll say, oh my God, it's so awful how many incumbents get reelected. Privacy, if you look at Google's Ngram, which measures percentages of words in English against all the words in books you notice that transparency has gone off the charts. Everybody's talking about transparency these days. And all three versions of deliberative theory, particularly the Civic Republican and the Habermasian, were absolutely opposed bargaining to deliberation. Bargaining bad, deliberation good? Well, no. I'm going to argue that we can find some good in these things. And the way we find, now why are these things good? It only takes, I think, just a little bit of thinking back to any negotiation that you've ever been part of to realize that long incumbencies lead to repeated interactions. Who are the great negotiators in Congress? The people who've been there a long time. There's no great negotiator who just walked across the Dorsville. So why is that? Why is repeated interaction so important? Because after I get to know you, I can talk to you, and you can talk to me, and I get it. I get your constituency, I get your needs, I get your ideology. I understand it from within, and I can begin to offer you something that's really important to you. Even if you've asked for A, I can offer you either A prime or B, and it'll be something that I'm offering because I know what you want, what you need. Privacy. Again, nobody's going to say anything if they know it's going to be on Twitter or in the news and so forth. And side payments. That's what negotiation is. Negotiation is trading on something that's of high value to me, but low value to you. Low value to you, and the other way around. So, because these things are the opposite to what we traditionally thought were what democratic values suggested, we need to look closely at them, and that's what this task force that one of the chapters in the book that Bob was talking about looked at, and asked, okay, under what conditions are these things okay? Under what conditions are they really good for democracy? It's not just privacy across the board, privacy sometimes. And we can go back to this in a question period if you want, because I've got some specific responses, but otherwise I just suggest you read that chapter. The point, whoops, here's one. I thought I'd taken this out because I knew the talk was going to go on a little too long, but my old slides got in, not my new ones. So here's an example. it's pretty obvious. I mean, all that the normative theorists did was they didn't go back to first principles. They just sat there and stroked their chins and said, well, you know, what actually lives up to our values, what's good? So side payments need to be transparent, they need to be required. There can't be corruption, you can trust the representatives. These are sort of, you know, but the point is that somebody's thought about it. Nobody had thought about it until I asked them to think about it. We all got together and tried to think, when are side payments good? Not just when are they bad things. So the conclusion at the top is we need to really reconsider the conditions for legitimate agreement. And as we do, we have to weigh more heavily the fact than the framers did back in the fact that we need a lot of legitimate coercion today. So, and when I say reconsider, I don't mean relax. In other words, I don't mean make it less democratic. I mean look at it and say what is democratic about it. So that's the. So now I want to look at the bottom for a moment, that would be, you know, the face of relatively illegitimate coercion. That's Ferguson, of course. And the question is, how do we achieve relatively legitimate coercion down the chain and at the point of application? My argument would be that all the things that we normatively apply to the legislative level, we would also apply at the point of application. So, consent, fairness, respect for persons, voice of the affected, telling the truth. Respect for persons would include Jerry Mashaw's idea of reason giving. Now he's talking about the administrative level, which is one down on that chain of legitimacy, the place of administrative rulemaking. And I think that, yes, this is a democratic demand. A law is more legitimate to the degree that reasons for the rules are given. But I'd also say that it's two-way. Do I have a two-way thing here? Yes, I do, okay. It's two-way. That is to say, it's not just the authorities giving reasons, it's the people saying back what they think of the reasons, or giving their own reasons that are contrary reasons, and having, I mean, this is in the best case, we're talking now regulative ideals, we're not saying that this is possible all the time, and it's certainly not possible in its ideal form ever, but this is the standard toward which we ought to be striving, that the coercion at the ground level is legitimate to the degree that there can be a sort of two-way exchange of reasons between the coercer and the coercee. Imagine, this is just a one-way thing, but supposing you're stopped for driving too fast on the thruway. The cop pulls you over, and in addition to giving you a ticket, he gives you a little pamphlet that explains why there is a 65-mile-an-hour limit. And it says, you know, this is the number of deaths at 55, number of deaths at 65, number of deaths at 75. 55 is obviously better, fewer deaths, but, you know, most people won't do that on a road that looks like this. And so we've picked 65. It seems like that's the best place. This is, you know, if you drive faster, this is the number of people on average that are more likely to get killed. What happens when you stamp on the brake? What's the difference in feet between the amount of space you can stop in at 65 and at 75? Quite a lot. It's much harder to stop at 75. What if a deer ran in front of, you know, a little teeny two-page pamphlet, not too expensive, and then possibly even, and here's a website that you can, if you don't agree, you can send in your reasons, and once a year the Commission on Traffic Safety will take a look at the reasons you argue that the speed limit ought to be higher at this particular point in the freeway. Now that's kind of silly maybe, but my point is that it exemplifies the idea of reason giving that should, I think, be behind the more legitimate forms of coercion that we have. And the more we can get toward that, the more legitimate that coercion is. Similarly, with the voice of the affected, we think of, in democratic theory, you hear the word voice, you read the word voice 3 times a day. But it's not just my voice, it's finding out that you've heard me. That's really important. So Emile Bruno and Rebecca Sachs at MIT did this fabulous experiment with Israelis, Palestinians, and Israelis, and or it'll work with any quote-unquote sort of oppressor group or more powerful group. The thing that really got the Palestinians to feel a little bit better about the whole situation, talking with this other person, was when the Israelis heard what they had to say and said it back to the Palestinians in their own in the Israelis' language. I mean, in other words, condensed and came back, sort of like the psychiatrist, I hear you saying, we all know this. If anybody's done any alternative dispute resolution, sort of, are you saying this? I hear you saying that. Well, it's tried and silly and all that, but it's the reason people do it is because that's what's important. So this concept of voice needs to be thought of a little bit more interactively as a two-way process. So what I'm getting at here in the more kind of broad strokes is that when we think about our ideals, before I drew a quite sharp line between empirical legitimacy, which is whether people believe that something's true, and normative legitimacy. I want to stay with that cleavage. But I want to say that when we develop our ideals, and I'm urging us here to develop our ideals, not just to stick with the ideals we've got, but to get thinking, get cracking, start trying to figure out how to produce legitimate coercion and how to make it more legitimate. We need to think harder, and as we do that, where do we get our ideals? We get them from our experience. That's the basic thing. We see people we admire, we live a life, and it's from the life that we live that we develop those ideals. So I'm suggesting that we start drawing on the lives we live to develop some ideals that we need in these situations. So what happens when you do that? What happens if you adopt the process that I'm suggesting? So I gave you a couple of counterintuitive things at the top. I'm now going to give you a couple of counterintuitive things at the bottom. Well, I've written about descriptive representation in legislatures. I think that descriptive representation at the point of implementation is also quite important. Now, that tends to go against some other values like meritocracy or colorblindness and so forth. But if I showed you the picture of relatively illegitimate coercion before, now I want to show you a picture of sort of relatively legitimate coercion. That's Captain Johnson in Ferguson. And he not only heard the protesters, he joined the protesters. He understood to a great degree, I'm not saying he understood 100%, he understood what they were talking about. And he said, look, we don't want to burn down your own neighborhoods. That's not the way to go about this. And that person was able to say that in a way that could be heard because he in turn was hearing. And he was able to hear because he was descriptively represented. He had lived, to some small degree, the life of some of the people who were protesting. So you might be thinking more that descriptive representation was a value you wanted to have at the point of implementation. You might want to think a little bit more about voice. And this I'm drawing from Tom Tyler's work. Because in an early book, Tom showed that convicted criminals often thought that the procedure was, felt more satisfied if they thought the procedure was fair than if they got an outcome that helped them, that was to their benefit. And then in another deeper study, he asked, well, what do you mean by fair? Well, fair meant, to some degree, having a voice, and not just having a voice, but being heard. So that actually, many criminals felt that plea bargains were fairer than what happened in the court of law. Because in the plea bargain, the guy or woman could say to the judge, look, this is the way it was. Tell his or her story and be heard, get some response. Whereas in the court, it was all party of the third part and objection, Your Honor, and gobbledygook and mumbo jumbo, and the actual person who was involved, the person who committed the crime or not, is sitting in the corner without the voice. So, you know, those of you who've read Weber know that he is more scathing about something he called Kadi justice than about anything else in his entire huge volumes. He despised Kadi justice. What was Kadi justice? Kadi justice is is King Solomon saying, whose baby is this? Well, let's chop it in half. Oh, you're upset? That's whose baby it is. That's just a wise person. That isn't a matter of procedure. That's what I'm sure all of you are sort of taught to not do. The system of law that's based on kind of universalism and whatnot is anti-Kadi justice. But it may be that certain features of, I'm not suggesting a return to Kadi justice, but it may be that certain features of Kadi justice, we notice that the actual people involved think that they're fairer. Well, I'm not saying they're right. What I'm saying is to take that experience and try to delve into it and see what is it that makes you think this is fairer, and can we pluck that out and learn something further more about it. Similarly, respect. There may be more respect for both the victim and the perpetrator in certain informal kinds of justice than in court justice. Legitimacy is often at the bottom considered, it's a matter of sovereignty, but consultation may do a very good job as well. Professional versus elected judges. I mean, election is the consent mechanism, but professional judges are perceived to be fairer. Maybe they are fairer. So this is a kind of an agenda-setting talk, basically. I kind of want to suggest that we need to be negotiating and thinking about and using our empirical experience to understand what it is about legitimacy at the top and at the bottom, what we ought to explore. Because, and this is where I started, the point is that we need it. We need it. We need a lot of coercion. A lot of political theory, normative theory, is about the resistance tradition. It's about protecting our rights, keeping those coercive folks at bay. And that's good. That's very good. But right now, we also need something else. We need more coercion. And the kind of coercion we should have, the better coercion, is the legitimate coercion. So let's start thinking about it. Thank you.
Questions?
I love questions.
Tom.
No, that's not fair. No, I bet he's saying, yeah, Jenny, go.
I agree with a lot of what you said.
So I'll start the questions since there seems to be. So, first of all, when you talk the way you talk, I want to use Occam's razor and say, what do you mean by consent, not these variables? So consent is itself a variable rather than an on-off.
Yes, totally.
And then the question would be, you're talking, it seemed to me you were much richer in talking at the implementation phase because you were talking face-to-face. And we all have some sense of what that looks like face-to-face. But the kind of coercion that we're going to need at the rulemaking level is not face-to-face. It looks more like the notice and comment of a rule, and we all know kind of does it or doesn't it create the legit. So can we scale up the kind of mechanisms that you're talking about? That would seem to me the challenge at the level of the rulemaking itself. How you go from the face-to-face to the relatively impersonal, which starts our whole problem off.
Right. Well, I don't see it exactly as a matter of scaling up because I see the same ideals at going at each stage. But if you're saying how do we increase genuine consent at the legislative level, I think, is Chuck Sable here by any chance?
Yes.
Yes, okay, so hi Chuck. So Chuck and Jonathan Zeitlin have done what I think is just brilliant work on the EU. their phrase is dynamic accountability. That what they argue is that the EU has developed a system in which the legally delegated level. So here you have citizens who elect people, who choose 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 people. And then those committees bring in stakeholders who are non-elected representatives. They're self-selected folks. They don't come with consent. They come with a mandate that's kind of self-given, but then reinforced by the mandate is made much stronger by the fact that these people are chosen by people who originally were elected by the citizens, picked these stakeholders to be stakeholder groups to speak for people. That group, those negotiators from the different countries come together, they figure things out, they begin to consult with stakeholders, and they produce a kind of cycle. So tell me if I'm describing this appropriately. A kind of cycle of innovation and a cycle of policy making in which things are tried, or they're floated, and then they're revised, and then they're tried again and floated again, and then you might bring in elected representatives. Everything's great about this. It really works very, very well, except you notice the citizens themselves are way, way back at the originator point. And I think that there would be ways of bringing citizens into this dynamic accountability, either on the consultative level through things like randomly selected citizen groups, or possibly by having, and I don't know how you would devise certain votes on certain things. The problem is that these are very technical issues. So you can't, this is why Robert Dahl suggested that there should be a randomly selected citizen legislature at the national level that would be a third house that would take very selected issues that needed a lot of study and would give a citizen voice on those issues. I think that's probably not in the cards, whereas I do think more of these citizen consultative groups are more in the cards, and there may be ways of having sort of public hearings and things. I'm not a big fan of public hearings because they're very self-selected and the dynamics are not deliberative, but they do have the advantage of being open. So it is a place for citizens. There are other ways you could bring citizens in through, for example, the EU ombudsperson at the moment. I don't think takes class action suits, but if they were to take class action suits, we would have people like them. In other words, it takes a certain amount of ingenuity to think about how you would build citizens back in, and so how you would build sort of real consent back in. But I think that if we took it as our job, we need to figure out how to make coercion more legitimate. We need to figure out ways of building into consent, more consent, where there is less consent now. We could do it. We're, human beings are learning machines. That's how come we, rule the world. We may blow ourselves off the face of the earth, but we've got here by inventing things, by thinking harder, and that's what we need to do.
Matthias.
So, Jenny, you started off saying there are certain situations where there's a need for coercion.
Yes.
And then you said, well, now let's see what conditions have to prevail for it to be legitimate. But I wonder whether this is this kind of two-step process is the most helpful way of thinking about it. Because you might say that the need is itself, if not a necessary or sufficient condition, at least a variable that's relevant for assessing the legitimacy of what is being done. And how it is designed. So the question, designed minimally intrusive, well-designed, appropriately constrained, so these kinds of substantive criteria. Imagine the following. If we have whatever the perfect procedure is, so we have all the voice.
In other words, you'd put a greater weight on if something was very much needed.
Yeah.
You'd say, oh well, we can relax a little bit.
We'd still want to get as high a mark as we can on this other stuff. But the point is the following: imagine we have
What about the other
Imagine
ones?
we have a really badly designed, not minimally intrusive law, but that went procedurally through all, did everything as well as we could possibly imagine. And now it goes up before a court and is challenged on sound constitutional grounds. I would think it perfectly plausible for a relatively undemocratic judicial procedure to strike down a law that was overreaching, that didn't fulfill, that didn't do well on the preliminary, in the preliminary areas, thereby suggesting that really that's always a core part of the overall legitimacy equation.
Yeah, let me see if I understand you, because I thought I was going down one road, and then I think I misunderstood you. At first, I thought you were saying if there is great need, we can perhaps relax our criteria.
Yeah, that's a part.
That was part of it.
And
so in response to that particular part, I would almost say the opposite. I would say the greater the need, the more important that it be legitimate, because it has to work. And its legitimacy is part of its working. So the more we need this thing, we really need it, the more important it is for it to be as legitimate as we can possibly make it. So that's on that one. The second one was in regard to proceduralism versus some of these other forms of legitimating. And there I would say that I think procedural niceties are very important. And I wasn't trying to say we should go with these instead of procedural niceties. I was saying that this was a more additive, that we should be paying attention to these as well. Now, sometimes they will come in tension, just as some of these things will come in tension with one another. I mean, it's not that good things don't all come in wonderful packages. They're often in tension, and then you have to decide. But I think, I hardly have to make the rule of law case in this room. And the procedural niceties, as petty as they may seem at times, are very much part of that. So this isn't a ignore procedural niceties argument at all. It's maybe they'll come in tension, maybe they won't. But I would give a great weight to procedural niceties. So, are you going to pick, or shall I pick? Well, Ian?
So, I wonder whether you've made enough of a case that we actually have greater need now for free access goods. And so there, as a matter of theory, in a world of, there are growth Clark mechanisms, there's provision point mechanisms where we can have anonymous large groups of people that provide public goods without coercion. And as a matter of practice, a large proportion of World War II was financed by voluntary taxes, which we called war bonds. And Indiegogo and Kickstarter have anonymous people that come together and fund things that are public goods. And I think right now there's a possibility that if we had where people could volunteer, and so you have this concept of consent, but it doesn't necessarily have to be at the top or the bottom. It could be, technology makes mass consent possible, that we could have 80% of the people would say, I'll make a carbon tax if at least 80% of my fellow citizens voluntarily consent to it. It doesn't have to be 100%. We could have an Indiegogo where we opt for 80% of us take the carbon tax.
Fantastic. That's what I meant by well-designed and minimal. That I completely agree that the more you can get that way, the better. And the more you can get without coercion, of the formal coercion, the better. And the more we can exercise, and you have been helpful in this, the more we can exercise our ingenuity to figure out ways like the contingent, if then, buy-in kinds of deals where you give consent, providing that other people do, the better. And when I said well-designed, this isn't just simple. Because as we know, extrinsic motivation drives out intrinsic motivation. So for those of you who don't know the work. You can have people, the classic study was you have people in the waiting room before they take them into the psychological experiment, and they're there with a bunch of puzzles, and they play puzzles. And then you get them in the experiment, and you pay 1/2 of them to do puzzles. And then you put them back in the waiting room, and you say, you're going to have to wait here for quite a while we do the paperwork. And you find that the people who've been paid to do the puzzles now don't do very many puzzles, now that they're back in the waiting room waiting for their check. So having paid them drives out. So when I say well-designed, that's something we need to pay a lot of attention to. And I think that we are, due to your work and others, we are beginning to develop lots of ways where we can not use formal coercion. And the more we can do that, and the more we, for example, in regard to the extrinsic of driving out the intrinsic, we now find that if you formulate the, well, this is payment rather than coercion, but if you formulate the payment in terms of an honor, then it doesn't drive out the intrinsic motivation. So I might be paid for giving this lecture, but it's like, oh, you're so wonderful, Jenny, and by the way, here's some money. And which money makes me give the next lecture. I mean, it's not that it's irrelevant, but it's formulated. It's not for every word you get $5. And so for recycling, if you give people discounts in the local stores and whatnot, it's because you're so wonderful, you've recycled. And here's some nice stuff that honors that. That doesn't drive it out. So I think we need to be quite careful about how we design the coercion. But I was only making the point that coercion is the problem of the 21st century. We gotta figure it out much better than we've been doing it. We need more of it. We also need much better design. So thank you for bringing that up. Let's see. I did take someone from the back, and then I'll...
Oh, thank you. Thank you so much. So you started out the lecture by making a distinction between people's beliefs about legitimacy and the truth of the matter about legitimacy.
Well, the truth, capital T, is a little heavy, but
well, and so I guess that's my question, is that do you think we need, a lot of what you talked about was procedures or way of exercising coercion. And I guess my question is, do you think we need a separate account as to what sorts of things actually are legitimate acts of coercion? Because I would say that, no amount of kindly listening by someone with military power transforms an unjust occupation, whether that be by an army or police force, into a just occupation. So do you think we need a separate account about that? Because we don't want law to sort of just
yes,
be hard sense
I do.
unjust.
Yeah. I mean, I think we need an account of legitimacy, legitimacy of process and justice of outcomes at the overall legislative level and so forth. And then at various stages down the administrative stages, various stages, and then at the point of application also. And while legitimate things that make the point of application more legitimate, by and large, they obviously can't outweigh justice and injustice at the other. Now you might say if they obfuscate injustice at the top, then that's a real trade-off. If instead of obfuscating, and if people are perfectly aware that the basic system is unjust, but the cop says, basic system unjust, but like, kind of, I get it, why don't you come? And so it's still a little bit better than, I'm not gonna mimic what the other ways you could do it, unless it obfuscates. If you're saying, then the obfuscation would be a real argument against sort of nicey-nicey at the implementation level. But by and large, I mean, even in deeply authoritarian regimes, things like, not murdering someone, or even going over the speed limit or something. These are things that are good for society, and so implementing them in a way where the coercion is more legitimate rather than less legitimate, unless it has this obfuscation effect, it would be better to do it that way. But I agree with you, they're two different things, and they're not just two different things. There's a whole set of intermediate bodies that need to also be as legitimate as they can be, or as legitimate as they can be. More legitimate, if possible. David has his hand up for a long time, and then I don't know, lots of them.
So I get that one of your worries, if we don't give an account and find ways to increase legitimate coercion, is that it's going to spill out in other directions. And I see the executive power, or unbridled executive power, as an obvious place where a lot of hopes for law are put onto these emergency situations. There's a different one I want to ask you about, which has become popular in some section of the legal academy, and it goes a little bit to the question, both the question with Ian and Lisa, which is nudging. And I can imagine that some kinds of nudges might satisfy, I mean, they might be well designed, let's talk about legitimacy. But there could be nudges that go so far as literally being like tricking people. And there's been some recent work that suggests that in some policies, it's precisely the extent that people don't know what's happening that they're efficacious. And so
oh, that's interesting, because I only know the nudges that are, like the little fly in the airport.
Ordinary nudging, we put the fatty food away from the cash register. I get that. We can all collectively consent to that and know that that's going to work with our impulses.
So give me the example, because I don't know it. I have to think of it new, of one where there's, because obviously lying, I mean, I had truth-telling as a big one here, which by the way, it just isn't there much in normative theory. It's something I put a big weight on.
Imagine a labeling on poisonous products that exaggerated the effect. So you're actually lying. You're undermining confidence in public health authorities. Say, these cigarettes will kill you in 5 years. It may not be true. But you see that they're getting at a point where you're actually lying to people. There's also some stuff about tax incidents, which is
first of all, lying is like many points against it because it's lying. That's bad. Then moving just to efficacy for a moment, moving from the normative realm just to the empirical realm, if people ever found out, that would not be good empirically for the Bureau of Cigarettes or whatever they are the next time around. So that's a hell of a risk to take just empirically. Leave aside the strong normative argument against it. So I would guess that nudges that involved intent to mislead, and I won't go so far as lie, but actual intent to mislead, I mean less than a lie, and it would be both empirically as well as obviously normatively problematic. I said Judith before.
So I might be going back to Lisa's question. I was struck by the account, the problem of governance that you pinpointed when you're dealing with Congress was polarization. But then when we came down to the law being enforced and we had the images of Ferguson, they seemed mismatched in some way. And also with the opening set of puzzles about the free rider problem and the kinds of collective provisioning for which we need law to enlist more broadly based participation and contribution. And I guess the Ferguson example struck me as odd in the mix because I had the instinct to say that the problem there wasn't figuring out ways to make coercion more friendly or more legitimate, but genuinely a problem of coercion, or rather that there was some problem of a failure of responsive governance there that was deeper than anything that I wanted to use Tom's work to try to fix. That I wanted to first go to that root problem, which was a failure of there being something like genuine democracy, a democracy that was worthy of respect there. And so that I found myself thinking when Ferguson was in the mix that it could be true that we have the problem with free rider and we also have the problem of polarization, but we also have problems of disfranchised people who lack voice in government, or government being run by moneyed interests, however we wanted to express what the problem of democratic deficit might be today. And that I wouldn't want to mix that kind of problem with the other problem for fear that I would set to work with the technique of legitimating coercion when what I needed was less coercion in the first place.
Right. Well, I know that those are two disjunctive places in the hierarchy, and I was doing it kind of intentionally. And let me argue that they are part of the same ball of wax. And Ferguson has to be disaggregated into the cop shooting Brown to begin with, and the control of the protests. So I was focusing on the control of the protests, just as, but they're both part of Ferguson. I mean, there are many, many other parts of Ferguson. For example, Richard Rothstein has done a terrific book showing that state action in the affirmative sense is responsible for Ferguson being, that little town being segregated, the people not having jobs, etc. He's got a wonderful paper showing how actual affirmative state action created the situation. But that's deep background now.
Actually, I was responding to that story of Ferguson when I was thinking about the problem of Ferguson. So,
oh, okay.
In other words, the idea that the community actually didn't have a voice in the government, and that this officer had been brought in from the state police, if I remember the facts correctly.
Yes.
So he wasn't of the town, and he was brought there because there was no one
exactly.
who was descriptively representative in the
Precisely.
town.
Yeah, no, that's right.
That being a problem of democracy, among other things.
Yes,
so
but it's a problem of legitimate coercion. Well, democracy is an answer to the problem of legitimate coercion. In other words, that's the best we've come up with. You know, we human beings have come up with to try to legitimate coercion.
Yeah.
So, and we do it at all these different levels. And there's failures at all these different levels. And there's a failure right now in the US at the legislative level because of historical circumstances. And the EU is also an important example for me of a need for coercion where it's very difficult to actually produce legitimate coercion. And so I think that what I'm trying to say is that we need this coercion. We need coercion to keep people from breaking into storefronts and setting fire to shops and so forth. Let's just focus right now on the control of the protests part of Ferguson. We need to be able to have coercion for that. We need to have coercion to create law and order generally. We need coercion to create all the blueberries on the table, lots and lots. And in order to do that, we have to have various ways of legitimating that coercion. I think we're failing at the legislative level in the US today in being able to produce legitimate coercion. And so my suggestions were about sort of tiny, not so tiny, but anyway, suggestions about how if we were to take the need for coercion, legitimate coercion seriously, we would take the stalemate in Washington even more seriously than we do now and begin to think. So similarly, at the Ferguson level, if we were to take the need for legitimate coercion seriously, we would have had more than just kind of a sort of good government, nice people like you and me saying, oh, it's really awful that there are white police in Ferguson, and before Ferguson happened, we would all have deplored the political situation in Ferguson. We would have said the people were pretty disenfranchised. But we would be talking about that in the 18th century language of resistance. We would be talking about it as these people's individual rights, et cetera, et cetera, et cetera. All of which is good. And I'm not trying to say we should. What I'm trying to say is that's where the focus has been. It's been against tyranny. It's been against individual rights. It's also true that we need legitimate coercion in Ferguson, and to make that a coercion more legitimate, the people of Ferguson should be, in a way, producing their own police officers. They did have to bring Captain Johnson in from outside, and that was wrong. That guy should have been there already. And if we were to think in terms of legitimate coercion, it would be another string to the democratic bow. In other words, right now we phrase a lot of this stuff in terms of individual rights. I'm trying to just sort of jujitsu it a little bit and say, it's also a matter of legitimate coercion, and it turns out that things are not that different, but in outcome. But this is a good argument for why the police in Ferguson should be black. This is a good argument for why the government should be, if not black, at least a proportionally represented descriptively of the people. Because they would be able to kind of understand, what I talked about in my article on descriptive representation is that there are moments of uncrystallized interest, moments when the political parties have not thought through all the issues that are, you run for office on A, B, C, D, F, G. Those are what I call crystallized interests, like class interests, like should there be a minimum wage or things like that. These are things that the parties have thought of. But there are many, many things that people, that representatives have to decide that are not things that they run for office on. And it's there that actually being from the community is very helpful, because you can say, well, we need to do this, or we need to do that. Now, whether they could have kept Michael Brown from walking down the middle of this, I don't know, but maybe there might have been some, maybe the community might have decided to spend its money on basketball teams for wayward guys. I don't know, but we do know that the coercion that was available to us collectively in Ferguson was deeply, deeply illegitimate. And so we didn't have very much to work with. So it's just another way of coming up at some of the democracy problems, not as a matter of kind of individual rights, but as a matter of our collective needs.
And I don't want to take time so you can go on, but I was just simply saying that when we were talking about it at the level of governance, the polarization issue was there more than the sort of set of processes that would lead citizenry to sort of feel.
Yeah, well, maybe I just was carried away by the fact that, I really loved the stuff in the report, and I wanted to put it in. I didn't think that was true, but now that I examined my motivations, it's possible that I just thought it was so neat that I kind of wanted to put it in. But the bottom line, which is that we need to rethink our democracy from the perspective of producing more legitimate coercion. I stick to that at the top, as well as at the Ferguson level. Well, I hope. I'd love to talk with people afterwards. Judith has had her hand up forever.
So I'm missing a piece about how to make visible your processes. You have a statement
That's an
called
interesting question.
transparency, but you don't actually describe a mechanism in which you gave, the example you gave of the leaflet going back and forth between the police officer giving the ticket or not. There isn't a disciplinary mechanism to build in third-party involvement and engagement and dialogic exchange, at least in the grids or description so far.
Mm-hmm.
And since I live in a part of the world called courts where that is declining rapidly at the lower levels,
Mm-hmm.
with increasing privatization of processes and outsourcing and the like, I'm curious to see what forms of coercion to coerce the processes of third-party interaction and engagement you would command.
Yeah. Well, believe me, I'm nowhere near there yet. So this is sort of agenda setting, and exactly how you do it is a whole other matter. But I will say that in regard to going back to the legislative level now, and thinking about the different things, privacy, side payments, long incumbencies, one feature of the conditions in which those are okay for democracy is that there are some, we didn't call it third party, although that's an interesting way of putting it. We put it as sort of some way of the citizens, but the citizens obviously work through institutions and intermediate organizations.
That's easier at the top. If you come to the bottom level of all your exchanges, that's where it's harder, I think.
Yeah, it could be, or you could have, there could be, if you were to think this was worth spending money on, and we don't have any money, we're in this blah 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 blah, and they're starving people all around the world, and how you spend your money is very vexed, and a lot of these consultative citizen jury processes, these things, they're really terrible. They're very unbelievable, and not just unbelievable, but undermining. Like sort of intent to deceive in a nudge. So undermining in the long run if you do them badly. So a consultative group has to be really pretty representative, and that's very expensive because the elderly Spanish-speaking, poor woman is not going to want to be part of it, whereas the retired, white guy is going to just love the idea of kind of going and giving his opinion. So it's expensive to bring together consultative groups like this. And again, I think we just need to use a little ingenuity about how we're going to build in voice and oversight, some sort of third-party oversight, because the stakeholder groups that they use in the EU, and they're a lot better than nothing, and I'm for stakeholder groups, but they're still a good way from legitimacy because of this problem of self-selection. So how we actually build in that oversight is a very important question, to which I don't at the moment have an answer.
So I want to say that the bad news is that it's 6 o'clock and we're going to need to adjourn. But the good news is that the conversation will continue downstairs at the alumni reading room, and we're all invited down for the reception. And thank you, Jenny.
Thank you very much.